Assalamu alaikum. Welcome to my channel. Today, I'm going to shed some light on another critical protection of fundamental rights enshrined in Article 199 of the Constitution of Pakistan, the Writ of Mandamus. This powerful judicial remedy compels public officials or authorities to perform their lawful duties when they neglect or refuse to act. The concept of mandamus has its roots in English common law and dates back to medieval times. It was initially a prerogative writ issued by the King's Bench in England to control subordinate courts and public officials, ensuring that they performed their lawful duties. Over time, this concept was adopted by many legal systems worldwide, including Pakistan, through colonial influence. Today, mandamus is a cornerstone of administrative and constitutional law, ensuring that public officials adhere to their legal responsibilities and uphold citizens' rights. In Pakistan, this right is codified under Article 199 of the Constitution, allowing individuals to seek relief in high courts when a public authority fails to perform a duty imposed by law. The term mandamus originates from the Latin phrase meaning "we command." It is essentially a judicial order that ensures public officials or authorities do not act arbitrarily or neglect their legal obligations. The writ of mandamus enforces legal accountability by compelling a government official or public body to fulfill their legal obligations. It ensures that public officials discharge their responsibilities according to law, thereby safeguarding citizens' fundamental rights. Under Article 199 of the Constitution of Pakistan, a writ of mandamus can be filed by any person who is aggrieved by the failure or refusal of a public authority or official to perform their lawful duty. The writ is typically filed in the High Court, which has the jurisdiction to issue the writs under this article. To file a writ of mandamus, the applicant must show that there is a legal duty or obligation that the public authority or official has neglected to perform. The applicant must also show that they have a legitimate interest or right that is directly affected by the inaction of the public authority. In other words, any person or entity whose rights or interests are adversely affected due to a public authority's failure to act can file for a writ of mandamus. The first step in the procedure for filing a writ of mandamus is to prepare a writ petition. The petition must clearly state the facts and circumstances that led to the failure or inaction of the public authority. It must also mention the legal provisions that impose a duty on the public authority and specify the relief being sought, which in this case is the writ of mandamus, compelling the public authority to perform its duty. The petition should include supporting documents that substantiate the applicant's claim, such as official correspondence, notices, or any other relevant material showing the public authority's refusal or neglect to act. Once the petition is prepared, it is filed in the High Court that has jurisdiction over the matter. The petition is submitted to the court's registry, where it will be assigned a case number. After the petition is filed, the High Court will issue a notice to the public authority or official against whom the writ is being filed. The notice will inform the respondent about the petition and direct them to respond to the claim within a specified period. Once the notice has been served, the court will schedule a hearing. During the hearing, the applicant's lawyer will present arguments to show why the writ of mandamus should be issued, demonstrating that the public authority has failed to perform its duty. The respondent will have the opportunity to present their defense or explain why they have not performed their duty, if applicable. The court may also ask for additional evidence or clarification on specific points raised in the petition. If necessary, the applicant may request interim relief, especially if there is an immediate need to prevent further harm. The court may issue an interim order directing the respondent to take temporary action while the main case is pending. After hearing both sides, the court will issue its judgment. If the court finds that the public authority has indeed failed to perform its legal duty, it may issue the writ of mandamus, compelling the authority to perform the required action. The court will specify the time frame within which the authority must comply with the order. If the public authority fails to comply with the court's order, the court has the power to take enforcement measures, including contempt of court proceedings. The applicant may also seek further legal remedies to ensure compliance. The court proceedings for a writ of mandamus generally follow the same process as other writ petitions. However, since the purpose of mandamus is to compel an action from a public authority, the focus is on the failure or neglect of the authority to perform its legal duty. The proceedings involve the presentation of evidence showing the public authority's inaction, legal arguments based on statutory obligations and constitutional principles, and potential directions for the authority to carry out its duties. It's important to note that the burden of proof rests with the petitioner to show that the public authority had a legal duty and failed to fulfill it. Filing for a writ of mandamus can be a crucial remedy to hold public officials accountable and ensure that they perform their legal duties. The process involves drafting a detailed petition, presenting it to the High Court, and following the legal procedures as outlined above. If you are facing inaction by a public authority that impacts your fundamental rights, this writ could be an effective way to seek justice. While mandamus is a powerful remedy, it has its boundaries. It cannot be issued to private individuals or entities against discretionary actions unless those are exercised arbitrarily or in bad faith, or if the duty has already been performed. For example, if a licensing authority unlawfully refuses to issue a license despite the applicant meeting all legal requirements, the writ of mandamus can compel the authority to act lawfully. Now let's have a look at some important case laws in which this writ has been applied. These cases illustrate how the writ of mandamus has been used to ensure public authorities fulfill their duties, uphold the rule of law, and protect the fundamental rights of citizens. In the case of Province of Sindh v's Public at Large, PLD 1988 SC 138, Tgate, residents of a locality filed a petition seeking a writ of mandamus against the municipal corporation for failing to provide access to clean drinking water. The Supreme Court emphasized that access to clean water is a fundamental right linked to the right to life as guaranteed by the Constitution. The court directed the municipal authorities to ensure the provision of clean water, establishing that public authorities cannot neglect their duty to provide basic necessities critical to human life. In Sharaf Faridi v. Federation of Pakistan, PLD 1989, Karachi 404, a citizen approached the court to compel the Karachi Development Authority to develop a designated area as per its statutory obligations. The High Court held that development authorities are duty-bound to fulfill their legal responsibilities and issued the writ of mandamus. This case reinforced the principle that public authorities cannot evade their duties under the law, particularly when such actions affect public welfare. The case of Fauji Foundation v. Shamimur Rahman, PLD 1983 SC 457, dealt with an employee seeking reinstatement after dismissal from a government organization. The petitioner argued that the dismissal violated statutory obligations. The court clarified that the writ of mandamus applies only to statutory duties and cannot be used to enforce private employment contracts unless the organization's actions breach statutory provisions. This case highlighted the distinction between statutory and non-statutory duties and refined the scope of mandamus in employment matters. In Arshad Mahmood v. Government of Punjab, PLD 2005 SC 93, residents filed a petition challenging the government's approval of unlawful construction projects that violated zoning regulation. The Supreme Court ruled in favor of the petitioners, issuing a writ of mandamus to compel compliance with zoning laws. The court emphasized that public authorities must adhere to statutory requirements to protect the public interest and ensure proper urban planning, preventing arbitrary administrative actions. In Syed Yousaf Raza Gilani v. Speaker National Assembly, PLD 2012 SC 549, the Speaker of the National Assembly refused to disqualify the Prime Minister after a contempt conviction, leading to a petition in the Supreme Court. The court, exercising its powers under mandamus, directed the Speaker to fulfill the constitutional obligation of disqualifying a convicted member. This case underscored the importance of upholding constitutional supremacy and ensuring that even high-ranking officials adhere to the law without bias or inaction. The writ of mandamus is not just about enforcing duties, it is about ensuring justice, accountability, and the rule of law. It protects citizens from administrative inaction or misuse of power and reinforces the principle that public officials are accountable to the Constitution and the people they serve. In conclusion, the writ of mandamus has a rich history and remains a vital tool in modern governance. It ensures that no public authority can act arbitrarily or neglect its responsibilities, safeguarding citizens' fundamental rights. Thank you for watching. Don't forget to like, share, and subscribe to my channel for more insights on constitutional protections. Stay tuned for my next video where we'll explore another important writ. Assalamu alaikum.